everyone, and welcome. I'm Jennifer Riggins. I'm your host, and today we're talking with Katherine Evans of Mirkwood Evans Vincent Law Group, and we're talking about standard essential patents, or SEPs. So, Katherine, why don't we kick off with you introducing yourself so we are grounded in your experience and why you want to talk about this today.
Thanks, Jennifer. Yes, as you said, I'm Katherine Evans. I'm the founding partner of Mirkwood Evans Vincent. I started the firm because I recognised that services, particularly technology services, were becoming international in nature and not based on a single jurisdiction. So I set up my firm with the intention of supporting clients anywhere in the world who wanted to do business everywhere in the world. And I very soon began to run into issues with patents and obtaining licenses for patents for clients and making sure that they could get fair licensing terms for those patents.
Okay. And what exactly is an SEP? Who would be interested in this? Like you said, I guess technology companies that are looking to scale, which in my experience is all technology companies. But
yeah, I mean they're very useful in the context of the automotive industry, the telecommunications industry, Internet of Things. If you think about the Internet of Things, where you want lots and lots of items to connect together, you need standard technologies to make that work. USB, Wi-Fi. But in terms of what is an SEP, maybe let's just start with what's a regular patent.
Yeah.
If I invent something which I think has a commercial purpose now or might have in the future, I'll apply for a patent for that invention. If that patent's granted, then in the ordinary course of events, no one else can use my invention without my permission. Because if they do, they're effectively stealing my invention, and I can sue them for damages if they make any money as a result of their theft. Mm-hmm. In that situation, the person who wants to use my patent has two main options. They can either try and obtain a license to use the patent with my permission, which means paying me a license fee, or they can challenge the validity of my patent. In the second case, they'll either argue that the patent is so obvious that it should be considered invalid, or they'll bring evidence to bear that someone else invented it before I did, and therefore that I have no rights to any compensation.
Okay.
In lots of situations, a patent owner will have an incentive to grant a license to the prospective customer because they'll want to commercialise it. But bear in mind that in some cases, they might prefer to keep a monopoly on their patent or grant different terms to different third parties based on whether the third party is a competitor or a non-competitor or friend. Someone supports my football team, so I'll be friends with them. Someone's supports the football team across the city, and I'm not friends with them, so I'm not going to grant them a license. Now imagine that the patent which was held by the monopolistic patent owner was so important to the development of a whole industry or series of technologies that refusing to share this patent with everybody on the same terms would harm economic development or competition in evolving markets. Now we're starting to think about standard essential patents, or SEPs. In order to make those kind of standards available to facilitate economic development and innovation, legal systems have come up with the concept of the standard essential patent owners licensing their technologies on terms which are reasonable and non-discriminatory. We love our acronyms in the legal world and in the technology world, so we use the acronym FRAND, fair, reasonable and non-discriminatory. And the basic idea is to ensure that essential technologies are available to everyone without the patent owner being able to charge excessive fees.
When do they become essential, that they're not regular patents anymore?
Yeah, well, that's an interesting question, Jennifer, because some patents in relation to 5G and 4G Wi-Fi were not considered essential when they were first patented, but now the argument is that they are essential. Whether you think Elon Musk is a superhero or one scar short of a Bond villain, in a case in point, he's recently objected to the terms proposed to license a range of 5G specific Wi-Fi patents. And he said that they are standard essential patents, and he's challenged the fairness of the terms on which the patent owner is trying to grant him those terms. Now, so far, his claims have been rejected by the UK courts on one ground but not the other. They agree that the patents in question are standard essential patents, but they say that based on what they can see, he's been offered fair, reasonable and non-discriminatory terms.
So at this point, all SEPs were regular patents before typically, or do they?
Typically they are. Typically when they start out in life, they're just regular patents. And then everybody begins to realise that actually we can't manage the Internet of Things, or we can't manage the rollout of 5G, or we can't develop cars which can operate without human intervention unless we have interconnectivity of these technologies, and then the technologies become identified as SEPs.
Okay. And then we started talking about that legal framework, the FRAND, the fair, reasonable, and non-discriminatory terms. What does that actually mean in practice, and who interprets or governs the definition of what those things are?
Yeah, so in the UK and generally around the world, organisations such as the European Telecommunications Standards Institute, ETSI, another lovely acronym, they decide what's fair, reasonable and non-discriminatory, and then the courts have to interpret it. Because as you can imagine, if someone's got a standard essential patent, they want to try and make the absolute best they can of it, get as much money as they possibly can before the courts say, oh, no, that's not okay. So we can look at a couple of the cases, if that's something you'd like to.
Please, yeah, examples always help everything. Yeah, please.
Okay, so there's a case of Huawei and ZTE Corporation, where the European Court of Justice established some guidelines for SEP holders who were trying to seek injunctions. So an injunction is where the patent holder says they can't use my patent at all unless they agree the terms that I want them to agree to. And the terms that were, the court said in that case that the SEP holder has to notify the alleged infringer and provide an offer for FRAND terms. They can't just apply an injunction and expect it to bite, because it could cause immense commercial damage to the party seeking the license. So they have to come forward with some terms. And then, of course, the issue becomes, are those terms fair, reasonable and non-discriminatory? And in another case involving Huawei, this time against Netgear, the court awarded a new form of injunctive relief known as a FRAND injunction.
Okay.
So the argument was, yes, I'll grant you an injunction if the other, to the extent that you're not agreeing terms which we think are fair, reasonable and non-discriminatory. If you then don't agree those terms, then we'll reapply the injunction. So the FRAND injunction in that case was awarded following findings that the patents were valid, they were infringed, they were standard essential patents. Huawei refused to grant a license on terms which were found to be fair, reasonable and non-discriminatory. But then when they did, it was said if Netgear then refused to enter into that license, the injunction would be enforced.
Okay. Now, we're talking about a lot of borders here. And Etsy, which I think we all know is much more of a different product, but the Etsy regulation, that's European and Huawei is a Chinese company. So how does that work? What court this is held in a European court? And then how does this factor in with your own role or your firm's role in this?
So what would generally happen would be a client would be based in a particular jurisdiction and they'd need to argue that their patent was being infringed in that jurisdiction or group of jurisdictions. So for instance, if you're Ericsson, if you're Nokia, you're going to apply in Europe to say somebody's challenging your standard essential patent. If you're a Chinese company, you're probably going to apply in China to say that your patent has been infringed. But most of the cases we're seeing, interestingly, are either in the UK, in Europe, or in the US. So it seems that even even, but Chinese companies also are looking to either apply for FRAND terms or say that licenses should be granted to them. There's actually an interesting case that was in the German courts where a Chinese company, Oppo, decided that its best argument was to come back and say that Ericsson's patent was invalid, and therefore they didn't have to they didn't have to grant a license on FRAND terms, but equally they could use it without a license at all. And the court actually eventually just said, oh, that's really not okay. They do have a valid license, and you do need to comply with the terms of a FRAND license. And the only issue at stake is whether or not the Ericsson license is fair, reasonable, and non-discriminatory. But it certainly makes for some fun in the litigation world.
And then if a case is decided in one European country, and I mean like EU country, does that mean that it's decided across the EU then, or?
Across the EU, yes. And then whether or not it's acknowledged by other courts will depend on the circumstances of the case. So, for instance, you may then have to look at it again in the UK. The UK will generally acknowledge the European Technical Standards Institute interpretation. So I'm not aware of any specific cases where they've gone against the European Court. Equally, the Europeans seem to acknowledge cases which have been brought by in the High Court in the UK. There's a general consensus amongst the big Western democracies as to how to approach these issues. And as I say, the companies in China and India are typically litigating these cases in countries where there are established rules about this kind of approach. But the case law is evolving all the time, because what's fair can change from time to time. What's reasonable and non-discriminatory can change, can evolve. And as you were kind of alluding to earlier, what comes within the definition of a standard essential patent can change from time to time, depending on how the technologies evolve.
Yeah, I was gonna say also, let's be honest, tech is going through a boom, just an insane amount of innovation right now, as we enter this world of AI, and just we're in this innovation, and tech moves very fast. Like, move fast and break things is a horrible slogan from it, but very popular one. But
yeah, so yes, I mean, Huawei have tried to run an argument that some of the patents for 4G wireless technology were actually invalid for obviousness. In other words, that if they hadn't been invented by the person they were invented by in 2011, they would have necessarily been invented later on, because they'd be required in order to move industry forward. I'm not sure how successful that argument's going to be, but it's an interesting one.
It's very interesting. And with technology moving so fast and courts being famously slower, how does that friction happen? I guess when is Mirkwood Evans and Vincent Law Group brought in, or a organization such as yourself that specializes in SEPs? When are you brought in? And how long do these cases last? I assume years, right?
These cases, yeah, I mean, they're they contribute to your pension, for sure. People would normally come in, and then we look at what the commercials are and what would be fair, reasonable, and non-discriminatory terms. So we try to look at it independently, as if we were acting for the patent holder. So what terms would we think were reasonable? What kind of industries are you going to use this in? What's your requirement? What kind of profits do you think you're going to make? We normally bring in accounting support, so that we can identify what the business case is for what's being proposed, and then have a look at what the licensing terms would be, and whether or not what have been perhaps those terms granted in the past are they still reasonable based on how much cheaper the technology is becoming, how much more adaptable it is, how many more players there are in the market. You know, something that 10 years ago may have been massively expensive, suddenly that the price is a tenth of what it was. Well, in that situation, maybe those original SEP licensing terms are no longer okay. So it's very much a negotiation based on as many facts as you can possibly bring to the table.
And as many subject matter experts that you can bring in. So I think that's very good.
Yeah, for sure. But also with trying to keep your client's costs as low as possible, because we tend to act for smaller technology companies who are involved in innovation rather than the huge companies who are trying to protect an entrenched economic position. And those people can throw an enormous amount of legal resource at a case. So it's very much about trying to identify the best information, the best evidence we can, rather than a massive amount of it, really targeted, really carefully put together, that just makes our argument look like it's going to win.
That's fantastic. And I think that's very thoughtful. And that kind of helps us understand who are you representing in these situations. So I know these are changing, just like technology is changing. It seems like the European Commission is looking to maybe do a new proposal for regulating SEPs to increase like transparency and predictability, I think. So can you tell more about that and what those that are listening should expect and how that may affect them?
I think that's very much in the context of artificial intelligence. And I think that a lot of countries are reconsidering their approach on AI because they realise that the industries of the future are going to be based on AI, and they don't want to miss out on those technologies by over-regulating them. So the European Union came up with some very, very strong regulation on AI, which they are now rolling back from. The UK decided not to go with the European approach, and again they're saying that maybe by the end of the year they'll come up with some regulations to try and limit damage to people's personal data, loss to people, but while still ensuring innovation. And nobody wants to be left out of these new technologies. That's where the new jobs are going to be, that's where the profits are going to be, and nobody wants their country to be left behind.
And frankly, patents become grayer when you don't know what percentage of it was created by something trained on someone else's patent that their staff accidentally trained an AI model in, and then that goes into something else. So patents should get very interesting very soon because it's very hard to find provenance in AI.
I was told by somebody once that it's a curse in Chinese, may you live in interesting times. We certainly live in interesting times, Jennifer.
That is very true. So as considering these interesting times, looking forward, are there any predictions you want to try to make or some bets on the evolution of SEPs and enforcement in the coming years and how that's always going to change these evolving licensing practices?
I would say that companies need to remain agile. They need to be always looking ahead, because what was a standard essential patent that was making them a huge amount of money yesterday may not be earning them that much money tomorrow, or it may not be as relevant tomorrow. So keep evolving, keep on your toes. That certainly applies to law firms as well. Embrace new technology where you can. Don't be afraid of it. Understand that pricing is going to go down. Understand that competition is going to increase. Understand that AI is going to change all of our lives.
Yeah. And we have to be ready for it and partner with trusted advisors such as yourself, Katherine, because those that are listening are definitely in the tech industry, are building the technology. They know their technology. They don't know the laws and regulations, and you shouldn't, because that's not that value you're adding. You just need to make sure you partner with those that understand it. So thank you so much, Katherine, for taking this time with me today.
Thanks, Jennifer.